Good afternoon, everybody. Welcome back. My name is Chris Justice. I'm an employment lawyer with Samfiru, Tumarkin. And as always, I'm here today to hopefully address as many questions as I can, all things related to employment law. So definitely get your questions in, whatever they may be. Could have to do with a contract you're having thoughts about or questions pertaining to. Maybe you've been let go, been offered a severance package, wondering if that's sufficient. Possibly you're going through an issue within the workplace while you've been working there. But again, whatever it is, get your questions in and I will do my best to answer as many as I can, as always. And also, as I normally do, I like to start off the session with a little talking point. This time around, I was going to bring up the issue of doctor's notes. I know this is a fairly common thing in my experience when it comes to people who maybe they're off on a workplace leave, disability leave. Maybe they're looking to come back from a leave. Maybe they've provided some doctor's notes, but there's some pushback from the company. Or maybe they just are asking me, what needs to be put into a doctor's note. A lot of times companies are asking people for a bunch of medical information. And most of the time, companies ask for more medical information than is necessary. So I figured it'd be a good time to kind of do a little refresher on the issue or the topic of doctor's notes. So with that said, just to start off, a doctor's note is essentially a document from a health practitioner, treatment provider, that basically confirms someone's ill or disabled and they either require workplace accommodations, or the doctor's note may speak to the person requiring a disability leave in order to get better and then eventually come back. There were some recent changes in Ontario law not too long ago that made it easier for employees to take short-term leaves of absence when it comes to illnesses without the need for a doctor's note. In Ontario anyways, basically, there's no longer a requirement for employees to provide a doctor's note for up to three days of the year. So this is under the legislation, the Employment Standards Act. And so at least as far as those 3 days are concerned, there doesn't need to be a note, and the employee just simply needs to let the employer know that they're taking a day off due to perhaps sickness or illness. There can be some instances where in the absence of a doctor's note, an employer will require some reasonable evidence of the need for the leave. But this can usually be done in the form of a self-attestation or statement from the employee just speaking to their inability to work, again, without having the doctor come into the fold and offer their thoughts or their 2 cents. But there are still instances, of course, where employers can ask for doctor's notes. So if it's a more prolonged absence, for example, more than 3 days, especially if it's weeks or months, or maybe if the employee is not saying that they can't work, but they just need some accommodations, maybe they've got a limitation when it comes to lifting or some sort of physical aspect, or if it's just a matter of confirming an employee's return to the workplace, say back to 100% or what have you. These are the instances where doctor's notes are typically required. And as far as what needs to be contained in the doctor's note, there's usually a few certain key facts or pieces of information that need to be included. One would just be in the doctor's note to confirm that the employee was seen or that there was a visit to the doctor, him or herself. An anticipated duration of the illness is another piece of information. So whether the doctor is saying, this person needs a week off, a month off, maybe more months off. So just an anticipated duration. And then just confirmation from the doctor that they provided the note to the employee. So whether it's in person or maybe there was a virtual meeting, something over Zoom, for example, but just that the doctor provided the employee with the note and then the employee is now providing it to the company. So yeah, there's usually a few pieces of information that are required, but often it's much less than what's normally asked for. A lot of times doctors will ask for someone's diagnosis. They'll ask for medication somebody's on. And a lot of times, most of the time, these questions go too far in terms of what is essential. And all that you really need to show the employer is just how long you're going to be off and what your limitations are. Those are the key things for that employer then to determine whether they can accommodate, how long they have to accommodate, and what degree of accommodation is required, because all employers do have a duty to accommodate someone up to the point of undue hardship. And so usually at least that bare minimum amount of information is required in order for them to do so. But there are also instances where I've seen employers challenge a doctor's note. So you may give a note to your employer, and your employer may say, this is insufficient, we want more information. Maybe your employer has some questions because perhaps you've given the company multiple doctor's notes and there's a bit of a contradiction in one versus another, or it's not quite clear what the doctor means in providing the note. Maybe there wasn't as much specificity as is needed. And so in some cases, definitely the minority of cases, not the majority, employers may be entitled to ask for some additional information, depending on your case, or even in rarer circumstances, an employer may require you to go through an independent medical evaluation or examination with an independent doctor, someone outside of your own treatment provider, outside of your own GP, maybe specialist, and get someone outside to do an independent evaluation. Again, usually this is only the case where there's some sort of contradiction or sort of significant issue when it comes to the notes that you're providing your employer from your doctor. So it's definitely a rare thing. You don't want to just be allowing employers to conduct their own independent medical exams or have another doctor do so, because it is a rare thing. So you want to give us a shout, give a lawyer a call first before agreeing to anything, because more often than not, the request to have you examined by someone independent is unnecessary. And it's just a way for the employer to try to gather as much information as they can, oftentimes with a view of trying to deny you in some way. So you don't want to necessarily, like I say, just agree to an independent evaluation. Those things are relatively rare. You also want to look at your contract, or maybe there's certain terms of your employment that talk about doctor's notes or what's required or what the company's policy is when it comes to doctor's notes. So you want to look at that as well before getting something from your doctor. Now, there are also some incidents where someone fails to give a doctor's note, or maybe someone refuses to go for an independent examination, and then they get let go. And so a lot of people will ask me, if I'm let go in a situation like this, what are my rights? Can I be fired if I fail to provide a doctor's note? Generally speaking, you can be let go, you can be fired. Although for the vast majority of these situations, if you are let go, you're still going to be owed your severance. And not only that, but depending on your situation, if you were let go in any kind of discriminatory fashion, maybe you were let go because the employer just didn't want to bother accommodating you, even if there was a legitimate note provided, then you could be looking at not only your severance, but possible damages on top of that for things related to human rights legislation. So usually at the very least, you're going to still be owed severance, but in some cases, you may actually be looking at a whole set of new damages as far as that's concerned. So there are also in some cases where people are let go for cause, which is even more rare. And then the employer basically says, we're letting you go and we're not giving you any severance. And in a lot of cases, that's just adding insult to injury. And again, the same sort of analysis would apply, because in most of these cases where you're let go for cause, for not having given a doctor's note, you're still going to be owed your full severance. You're still going to be owed potential human rights damages. And then if it's specifically for cause that you're being let go, you may be owed even further damages on top of human rights under the umbrella of bad faith. So I think there's a lot to consider, both from employees and employers. Employers have to be definitely wary and cautious that they don't just, let somebody go in these cases, because, they could be opening up a can of worms beyond just the severance. So it's a lot to consider on both ends. But I still recommend, if you're an employee in this scenario, before having a lot of back and forth information exchange with your employer, before giving up all this medical information, or before just communicating with your employer about what's reasonable or what isn't reasonable, you definitely want to give us a shout, so that, we make sure that you're not saying anything that could come back to bite you. You're not saying anything that could play into the employer's hands. And then we can sort of help stick handle the matter with you and make sure that everything correctly is being communicated so that you can preserve your rights, or at least give yourself more options later on down the line if the employer decides to take some sort of a drastic action or tries to escalate the situation. So yeah, that's kind of what I wanted to just touch on at the top of today's show. I'll get into, if we've got some more time, the rights of older workers in the workplace and some of the issues or considerations that go into that aspect of things. But before I do that, I'm just going to get into some of the questions while I have some, just to make sure I answer everything within the time allotted. So I've got one question in from Bullish, who's saying that they recently submitted their 14-day resignation notice to their manager. So I guess giving them 2 weeks of their resignation. They requested to take part-time hours off, but the request was denied. Some friends of theirs had apparently planned a trip, and a few of them are moving away after the winter break. So that's why it seems like there was a resignation, so they could join their friends on this vacation. But again, the managers denied the resignation notice, saying that they were supposed to give them notice for a month prior. And the question is, what can I do? And can my manager legally do this? So normally there is some amount of notice that will need to be given for someone to resign. In a lot of cases, that amount of notice is usually 2 or maybe 3 weeks. There are some instances where more notice is required. For example, if you're in a more senior role, a role of which would probably be harder to replace if you've left than maybe more of an entry-level role, there could be some obligation to provide more notice. But most of the time, in order for an employer to require more than your standard 2 or 3 weeks of notice, there's got to be something in your contract that speaks to that. So you may have something in a contract that says if you're going to resign, you have to give them a month's worth of notice, or 6 weeks of notice, or 3 weeks of notice, whatever it may be. And you want to try to adhere to the terms of the contract. But in terms of an employer rejecting someone's resignation, I mean, look, if you're going to quit your job, most of the time the employer can't stop you, and it's going to be your decision to resign. An employer can't keep you there. Now, sometimes, though, if you've got a contract that says you're supposed to give an employer, let's just say, a month's worth of notice of your resignation, and you only give them 2 weeks of notice of resignation, there may be, not always, and in fact, probably most of the time not the case, but in some cases, there may be a requirement for you to have given more notice. And if you don't give your employer notice to the extent that you're required, let's say you give them a week or 2 less notice than you're supposed to, there could be a possibility that the employer could take some form of action against you in terms of trying to recruit that week or 2, maybe going after you for breach of contract if it isn't a contract of yours. But normally your employer can't legally prevent you from resigning. It will just be a question of whether or not after you've left, your employer decides to take any sort of action against you, say for that extra week or so that you were supposed to give them in terms of your notice. But in a lot of cases, even if there is another week or 2 owed to your employer, the idea that they're going to go after you in court or go forward with some sort of lawsuit in most cases probably doesn't make sense practically. So it could just be an empty threat from your employer. But I think in these situations, you want to give us a call, give the firm a call, set up at least a phone call consultation just to make sure everything's being done right, just to make sure that we can review a contract if there is one in place that might speak to the issue of resignation or not. And also just to let you know kind of what the next options are or what the possible consequences may be in terms of the resignation. But if it's not a huge impact to the employer, highly unlikely they're going to take further action against you. They may just be trying to strong arm you, in a manner of speaking, into staying around. But don't think that you need to necessarily stay around because they're asking or that they're requiring that of you. But definitely give us a call if you're in a situation like that one, Bullish. I've got another question in from Sir on YouTube who's saying that they were passed up for a job because they didn't have the skin color. I guess the employer didn't, this employee didn't have the skin color that the employer wanted. And is this a human rights issue? Can I still file a claim under ultimate limitations? So if you can prove that you were denied an opportunity, whether you have the job or not. Maybe you're working at the company and you're denied an opportunity. If it's on the basis of skin color, that would be within the realm of human rights legislation. Now, the question, though, is can you prove that there's discrimination? So short of the employer saying, we're not hiring you because you're black or white or Asian or brown or whatever the case is, how are you going to prove this? That would be one issue. But if you can prove it, maybe there's some communication, maybe you've got a witness who is within earshot of hearing that, then absolutely that's a human rights violation, and the employer could be on the hook to pay damages under human rights legislation, even if you didn't start the job. It doesn't necessarily mean that you're going to get severance if you don't have a job yet with that company. But at the very least, you could go after them for those human rights damages. If you have a job and you were passed up a job, while you're at that employer because of the color of your skin, then that could be an automatic termination and entitle you to your full severance, and as well potentially those human rights damages on top. So definitely a huge issue for employers that they're going to want to avoid. But if that's something that you as an employee have experienced, definitely want to give us a shout, because that's a very serious matter. I've got another question in from Nine Crew, who's asking, if I work as a YouTube driver, do I have to pay my own taxes? So if you're an Uber driver, I think I said YouTube, but if you're an Uber driver, my understanding is that you may very well be considered or be viewed by some people as an independent contractor. Whether you are an independent contractor or not, if you're getting paid and no taxes are coming off, then typically you would be responsible for filing your own taxes. Whether or not, like I say, that factors into you being declared an employee or not is a different question altogether. So just because you may think you're a contractor, or you may be told you're a contractor, whether you're working for Uber or some other company, don't automatically assume that you are. In fact, most of the time, people who think or are called contractors are actually employees that are owed severance if they're ever let go. But that still doesn't preclude you or prevent you from having to file your own taxes if the company's not going to do it. You want to make sure that you don't run afoul of any tax implications or anything under tax law. So I would definitely recommend you do your own taxes. But again, whether or not that means that you're an employee or not is an entirely different question. I've got another question in from Abby on YouTube, who's asking, if they leave a management position, how much notice do they have to give? So again, the more senior your role, typically the more notice is required. But if there's not something specifically set out in a contract, I would generally recommend trying to give as minimal notice as you can, maybe 2 or 3 weeks, unless for whatever reason you want to give more notice. Maybe you want to stick around, finalize some projects that you've got there. And in that case, it may make sense for you to ask for more notice, and your employer may give it to you. But if the concern is, I don't want to be there longer than I have to be, then again, I would first look at the contract, see if there's anything specific there. And if not, you could try suggesting 2 or 3 weeks notice, see what your employer has to say, and then go from there. And if anything, reach out to us afterwards to kind of confirm, based on what the employer's response may be. But 2 to 3 weeks notice is generally an accepted minimum. But thank you for your question, Abby. I've got another one in from Renee, who's asking, if a company is known to be stubborn in regards to statements of claim, how does an employment lawyer deal with them so that their client doesn't have to wait over a year to get what's owed? It's a good question. Unfortunately, if a company wants to be stubborn and they don't want to pay you what you think you're owed, the only recourse you have is to pursue your rights through litigation. And sometimes when you sue a company, after you've served the company with papers, they try to settle. But there are other cases where you sue a company and you serve them with papers and they don't want to settle. And you may have almost a slam dunk. You may be owed 50, 100 grand more. And the lawyer may be saying that you have a very, very good case. But that doesn't mean that you can force the employer typically to pay out what you're asking for within a year. And you just may unfortunately be in a scenario where if you want to get what you're owed, you're going to have to go through the hoops of litigation. But it's not to assume that it will take a year. It could, frankly, anytime you sue a company, it could take anywhere from maybe a few months to settle to possibly 1 or 2 or 3 years. But like I say, until you get a court order from a judge that orders the company to pay, and if not, further consequences being put forward, you're just going to have to go through the litigation process and hope that the employer comes to their senses when it comes to paying you out some money. There's just no other way realistically to get a deal done and a court order in effect in that short amount of time. Maybe at best you could get it done in a year if you put it on the fast track and you get lucky enough to get an early trial date. But otherwise, you're going to have to decide what you want to do in terms of pursuing litigation and going after a bigger amount of money, or considering settling without a lawsuit and taking a compromise on what you may be potentially owed down the line. Got another question in from Aiden on YouTube, who's asking whether an employee can choose not to attend a scheduled shift at a retail store if there's no policy on absenteeism. And they're asking whether we have cause to provide an official warning or terminate the employee. So I think this is being asked from the employer's perspective. I don't think you necessarily need a set out policy on absenteeism in order to discipline or terminate someone for not showing up to their job. I think that if there's a contract in place that says, for example, you're to work here Monday to Friday, 9 to 5, and an employee chooses not to attend a shift, say on the Monday or Tuesday or Wednesday or whatever day of that week, from an employer's perspective, I don't think that one absence is going to be enough to terminate the employee for cause. I think that if you can establish, though, that this happened multiple times, and you can also establish that you've given the employee a warning or multiple warnings after they've not showed up to their job, that's going to put you in a better position. So it's not as though you have to wait months or years of ongoing absenteeism to let somebody go for cause. It's generally pretty well understood that if you've got a job, certain amount of hours or days in a week, you show up and work those hours or days, especially if it's in a contract or it's just been established through the passage of time. So I would say from an employer's perspective, the first time someone is absent from the work without any justification, you want to probably consider giving them either a verbal warning or a warning in writing and letting them know that they've not showed up, that this is in violation of the terms of their employment, whether those are in writing or not, and that they're expected to show up for work, the following day or whatever the next shift is. And let that letter stand as a warning that if this absenteeism continues without justification, that further disciplinary action may be required up to and including a possible termination. And in that way, you put them on notice, you've got something in writing, and you've let them know about the consequences if this continues. And so if you've got, say, one maybe written warning on that, and then they don't show up the next day, you send another one. And then if it happens a third time, you may be within your rights to say, 3 strikes and you're out, because being on time and showing up for work, it's sort of a black and white thing unless somebody's got an explanation for it. And employers don't have to be having this, like I say, go on for months and weeks on end before they can let go of someone for cause. But you do want to make sure before you jump to cause that there's at least some documented history, maybe at least a couple warnings, setting out those consequences, letting the person know that this is a violation. And then maybe after several times happening, which might be several times within 1 week, you could then move to a potential just cause termination. But I would say if you're an employer, you definitely also want to give us a shout just before you pull the trigger, because you want to make sure that you've crossed your T's, you've dotted your I's. And I see there, Aiden, that you're saying it might be a premeditated absence for unjustified reasons, and that, if anything, would just go further into your favor. If it can be established that it was premeditated, maybe you've got an email, maybe you've got some evidence or some correspondence from the employee that gives you reason to believe it was premeditated. It's not, due to something related to illness, for example, and it's unjust, then yeah, the courts are going to only put up with that for so long, and people are going to be bound to agree to the terms they agreed to. So give us a call, Aiden, if it's becoming a problem, if there have been several absences and several warnings given, especially because, like I say, you may be in a position to say, at this point, if you don't show up on X date, given the history that's happened before, given what we know, or premeditation or otherwise, you can then look to put an ultimatum or a final warning together. And if they don't show up, have a much better chance of establishing cause and not having to worry about, are they going to sue me and having to look over your back kind of thing. But I appreciate the question, Aiden. Thanks again. I got another one in from MP who's asking, if a performance appraisal does not dictate a raise for someone who reached the top of their pay grade, is a performance appraisal mandatory from an employment law perspective or just good practice? So I don't think a performance appraisal is required by law. I definitely think it's a good practice. You want to try to make sure that the employee is aware of how they're doing or how they're not doing. And also, if you're going to some point later on down the line rely on somebody's performance as a means of letting them go, especially if you let them go for cause, you as an employer do want to make sure that there's documentation on the file, that there were performance meetings, one-on-one meetings, maybe warnings sent to the employee regarding their performance saying, if it doesn't pick up, we may have to consider letting you go or take further action. So yeah, not mandatory, but definitely a good practice to have, because otherwise it just might be harder for the company to establish that, you were let go or that they let somebody go based on performance related reasons. But if it ever becomes a problem, MP, definitely give us a shout. I appreciate your question as well. I've got another one in from Stephanie who's asking, is your employer allowed to cut off your benefits if you're on short-term disability? They're not cutting off disability benefits, just everything else. So that may depend on the benefits policy for that particular employer. A lot of times, if somebody's on a disability leave, their group benefits, their general group health, life, dental, in most cases, from my experience, has continued. So I'm not sure why the cutoff is happening, if they're relying on something to do with a different short-term disability policy. Maybe it's through an insurance company, or if there's some other policy within the organization that speaks to that. But even if you're on a disability leave, you're still technically an employee of the organization. So there could be a problem there if other benefits are being cut off. So you definitely want to give us a shout earlier rather than later, just so we can get ahead of this. But thank you for your question as well. I've got another question in from George, who's saying that there are 12 years working in an environmental company, dismissed without cause, no severance given. Reached out to a lawyer, asked to pay $600 down payment, another $400 an hour. I don't have the money to pay yet. So what I can say there, George, is if you want to give us a shout, we can set up a consultation. The consultation likely can be free, just to flush out your situation, the circumstances involving this dismissal. And we do have a possibility at our firm to potentially offer our services on a contingency basis. So if you're 12 years in with a company, you're let go without cause and there's no severance provided, bit of a red flag from my perspective. It seems like normally you're let go without cause, you should be getting severance. And as a 12-year person, you could be looking at a year or more of severance. So yeah, give us a shout. Like I say, we help out a lot of people without requiring any money up front for them, depending on their case. So if the concern is that you don't have the money to afford paying a lawyer on an hourly basis, then perhaps we can do something where we work out a contingency fee basis, where we don't charge anything unless we get you money. And if we get something, we can look to take a percentage of that. And that might be a happy compromise for everyone involved, because it does seem after 12 years, that's a long time to be getting no severance when, potential is over a year for you. I wouldn't want to see you kind of walk away with nothing in hand just because of possible lawyer fees needing to be paid. So appreciate you calling in as well, or sending that message along, but definitely give us a shout to set up a consult. I'm going to answer one more question just from Cosmic, just before I let everyone go for the day. So Cosmic has sent a note saying, excuse me language, but my boss is a scumbag, stealing hours, not giving paid time off, holding bonuses, lying about job benefits, and it's a corporate store. Yeah, there's a lot going on there, Cosmic. I mean, it definitely seems like promises were given that weren't followed through with, or even a breach of the terms of your employment has occurred if you are saying that you are entitled to certain things and now they're not giving you those things. So whether it's them promising something and not adhering to that promise, or them agreeing maybe something in writing with you as far as hours or bonuses and holding that back, that could be a huge problem. Breach of contract, that could be a constructive dismissal, and that could allow you to treat this like a termination and go after the employer for your full severance and possible additional damages for bad faith. So give us a call as well, Cosmic. Appreciate you reaching out as well. There definitely seems to be some potential there. But that's going to do it for my time today, everyone. I thank you as always for sending in your questions. We've got these Q&As going on all the time. Right down below there, we've got a Q&A with Mr. Samfiru himself, 1 o'clock on Wednesday. So for those that I didn't get around to answering questions, or maybe you've got a question you're holding off on for Lior, definitely tune in this Wednesday, get your questions in, and he'll, I'm sure, answer everything to the best of his abilities. But otherwise, do take care. Enjoy your Monday, and all the best. Bye for now.